Aloha, ladies and gentlemen. I'm back in the mainland, as you might have noticed. Another episode of Ask Me Anything. Hope you're all doing well. Question number 1. How can my mother remove her husband as the executor of her trust and designate me instead? First, there is no executor of your trust. It's a trustee. That's the right term to use. My mother has made her husband, my stepfather, the trustee of her trust for 30 years, but due to his dementia, we were afraid that he might not be able to handle the responsibility well in the following years. So she wants me, the person asking this question, to be the new trustee. Do they both need to go to the attorney's office to make changes to documents, or can she just call and ask the attorney to change it and send her a new copy to sign? Does she need her husband's permission and approval to change it? Both my mom and stepfather are very ill. This is a keyword. Both mom and stepdad are very ill, so they can't leave their home safely. We are all in California. So this is your mom's trust. I'm assuming that stepfather has nothing to do with this trust other than the fact that he is the trustee. What does that mean? That means if the trust was revocable, your mom can change anything inside of the trust if she wanted to. She could also remove the trustees just like that. And how do you do that? Well, read the trust document. Do you have a copy of it? Did your mom give you a copy of it? If she doesn't have it, yes, call the attorney and tell him, hey, we want to remove stepdad as a trustee. What do we need? It's usually a simple form, something in writing that mom has that says, I hereby remove stepdad as trustee and I appoint this person instead. If this is an irrevocable trust, if this is a revocable trust, a grantor trust where your mom still has the power to change or amend it, then she most certainly has the power to change her trustees at any time that she wants. All she has to do is put something in writing and hand that writing over to your stepdad and giving him notice that he's removed as trustee, and then appoint you as the new trustee and create a new certification of trust. This is a document that she signs, that you as trustee will sign and notarize, officially telling anyone who asks that you are now the new trustee. It's that easy, very easy. So don't worry about it. Just call the attorney. They don't have to go to the attorney's office. Your stepdad doesn't need to give permission. Your mom can do this unilaterally without getting his permission. She just has to inform him that it's happened. And the attorney can mail the documents over to your house. It's nice and simple like that. I love that question. All right. Second question and last question. We're going to keep it simple today. If my children predecease me, I want my grandchildren to inherit their parents' share of my estate. Do I need a special provision in my trust for minors? Yes, absolutely. So legally, minors cannot inherit anything. If ever you have either a trust or a will giving something to a minor child, it is illegal for the executor or your trustee to provide those assets to the minor child. They have to either give it to their guardians, hold it in trust, or give it to their parents. So usually what we do is we dictate who is a minor child. You have the power to do that. It doesn't have to be someone 18 or 21. You can say if you are under the age of 25 or 27, maybe a little bit more of a financially literate age to be inheriting assets, that can be considered a minor. And then if it's through a will, all wills have to go through probate court. The judge is going to say, oh, first your minor child has to hire an attorney, right? Because your minor child's interests have to be protected. And then the judge is going to say, all right, well, we can't just give money out to the minor child. We're either going to set it up in a trust or put it in a custodial account that is managed by that attorney. So probably doing this through a will is not a good idea. Maybe if you set up a trust, in your trust, you can say, I give everything to my children, but in the event that they are deceased, it goes to my grandchildren. If my grandchildren are under the age of, my rule of thumb is 25, then the money will be held in trust, used on their behalf, and given to them until they reach that age of 25, at which time they can tell the trustee, it's my money, give it to me. Or if you want to put a little bit more legal protections in there from their creditors, you can hold it in trust for their lifetime. And throughout their lives, the money can be held and used for their benefit, but protected from their legal situations, like their creditors, their divorce, their bankruptcies, their lawsuits. Huge gift that parents can give their children. One of the best legal protections that parents can give their children and grandparents can give their grandchildren. If you want to talk more about this, I'll be happy to. This is basically the definition of a trust fund baby. Think about that. and ask more questions as they come. All right? I hope everyone's doing well. Take care.